Hi, I'm Ray Jr. of Foreclosure Miracles, and you're watching What to Do Next When You Find Out You're in Foreclosure. So you got the letter, didn't you? I've gotten that letter twice, the one where they tell you you're in foreclosure, and your first instinct was probably to freak out. Well, guess what? Believe it or not much to panic about, at least not yet. There's still a ton of options, especially if you just got your letter. Now, having said that, if you're watching this video and you got your letter like 30, 60, 90 days ago, you need to act immediately, because a lot of the options I'm about to discuss in this video are not available to you anymore. Now, as long as your house hasn't gone all the way to where they've gotten the default judgment and they're setting a sale date, there's still things that we can do. And sometimes, even in that moment, the options are a lot more limited in that moment. Once you've gotten that far along and you've waited that long, you're really going to have a hard time saving your property. Now, that doesn't mean we don't still have options. We still have plenty of options we can help you with, and we can discuss those with you. But for those of you who have just gotten your letter, don't put yourself in that position where you don't respond. So the video today is about exactly that: how to respond, what to respond with, but it's got to be with this understanding. We are not attorneys. This is not a law firm. There's nobody on staff that's an attorney. This is all personal advice from me, because that letter that you got, I've gotten 2 of them. I've been in foreclosure not once, but twice. And because of that, I know how to sort of work this process both from the inside, because I've been in foreclosure twice, and from the outside, because I've helped a ton of people resolve it from the outside. So I do know what I'm doing, but that doesn't mean I'm giving you legal advice, because I'm not. The absolute best advice I can give you is to get an attorney once you go into foreclosure. But if you're not in a position to be able to afford one, or maybe you're in a position where you want to know what some of your options are without having to pay people, this is a great starting point. So again, not legal advice, but some stuff that we know because we've been in this field for quite some time. So let's talk about a couple of the questions you're probably asking yourself. The big one that's probably pounding around in your head, just like it was in mine, is, oh my God, how much time do I have? You're going to find that most people are unwilling to answer that question. So let me give you some very clear, very straight up answers to your question. The answer is, if you just got your letter, it's about 3 months. But there's no hard and fast rule. Some foreclosures take years. Some are done in a couple of months. But on average, especially now, there was a huge glut of them over the last few years, but that's all cleared up now. So especially now, it's actually about 3, maybe 6 months if you're really, really lucky. But on average, 3, maybe 4 months. With that in mind, you need to move quickly, because here's the thing, and you've got to understand this. Between now and the day when they take the property, there's this slew of options that are available to you that we can take advantage of. The problem is, every week or so, another one of those options comes off the table. And each time you wait and don't move and don't do something, you're going to be in a position where you have less options to solve your problem. Now, let me tell you the number one reason that people don't move on trying to figure out how to solve their foreclosure. It's because they think, if I do something now, I could lose the 3 months that I would have had if I start contacting the bank now, or if I call Ray right now, or if I take some action right now, I'm going to lose that time frame I have to sit back and think and whatever else. Because if I start moving now, I got to start making payments now, or I got to start solving this now. No, that's not true. So that's certainly one way that can be handled. That is not a requirement. The problem is, while you do not have to act right now as far as solving the foreclosure by making a payment or whatever, you need to start communicating with your bank right now. And you don't want to do that on your own. You want to let somebody, either an attorney or us, handle that for you, because we're not scared of banks. We're not stuck in a position where we don't have money to resolve your problem. And we're on your side, not the bank side, which means you're not stuck either. So you want to let somebody else probably handle that process for you, whether it's us or someone else. It's better to have a third party that's not mired in the emotion of your home going through that process for you and on your behalf. But the critical thing to remember is this: just because you start talking to your bank doesn't mean you took the 3-month process and shortened it to, well, then we're gonna have to do it this week because now they know me and they got my phone number and whatever else. I got news for you. They already have your phone number. They know exactly where to find you because they know your address. So they know what to do and they know how to find you. When you don't respond and you don't talk to the banks, you shorten the time frame, not lengthen it. That's the other critical thing that you need to know. Please don't forget what I just told you. By kind of putting everything in a drawer and saying, I know I got 3 months, so I'll deal with it later, it actually shortens the time frame, not lengthens it. So what I'm saying is, with the right moves and the right attitude and the right things going down the path, we can take that 3 months, maybe turn it into 6 or 9 or 12, kind of depending on your circumstance and what the bank will allow, and buy you some more time. And the cool thing is, not that we're promoting this, but you're living rent and mortgage free during that time. So we can help you elongate that process. But the problem is, the more options that you run out of by waiting longer to get to us or somebody else to help you, the less time frame you're going to have. So if you get closer to the 3-month mark, we might only be able to extend you by a couple of weeks, or maybe even only a week. But if you start more towards the beginning, it gives us a whole bunch more options to really kind of push this back and keep that ball rolling for you. And here's the great news. Not one of our services costs you a dime, nothing. So how do we make money? Well, invariably, there are people whose homes, they simply can't solve the problem. That's where we step in. That's where we come in and say, look, we're going to help you solve this problem. We do the best we can. And while there's no guarantees that we can actually help you, in many cases, we find you a new place to live. We pay a couple months worth of your rent. Many times we can put cash in your pocket, depending on the demands of the bank. And almost every time we can put food in your pantry, at least to keep you moving. But again, remember, a couple months free rent, more than likely. So there's a lot of things that we can still do, even in the scenario where you might lose your home. So you want to make sure that right now, while you're sitting here on this page, the little web form that you see right there, fill it out. Tell us who you are by saying hi. Just, shoot a message over to me with that web form. Tell me a little bit about your situation so I know what's going on. I'll call you pretty darn quickly after getting the form from you, and we'll start to work together to figure out some of your options. But the critical thing is, don't wait. Don't wait. Fill that form out right now. Even while I'm talking to you, fill out the form. There's no obligations. It doesn't cost you anything to work with us anyway. So fill out the form right now. We're not going to spam call you. We're not going to spam email you. We're not going to add you to a list or put you on something else and make your email, your phone blow up and go crazy. We're not going to sell your information to other people. It's all confidential, and we're extremely non-judgmental. We take really good care of you. It doesn't matter what your situation is. So now, having said all that, let me talk to you about the next big question that people are always asking. The first one is always, how long do I have? The next question invariably is, what happens next, and what do I need to do? Now, this part of the video is super critical that you pay attention to, because there are some things that I'm going to tell you to do, especially if you just got your foreclosure, and you need to do them exactly like I'm going to tell them to you. Now, having said that, again, I need to remind you, we're not lawyers, and I don't give legal advice. This is just friend to friend telling you what I've been through and what I've seen other attorneys do to get you going down this road in a way that you're not going to hurt yourself. The first thing is this: you've received some kind of a document from the court that's usually rather ominous and scary and looks like they're going to come get your home today. Well, the great news is they're not coming to get your home today. It's going to take several months. They've got a lot to prove in court before they can take your home from you, which buys us time to try and save the home, which I know is your number one goal. You want to more than likely save your home. Now, for those of you that are saying, look, I don't want to save my home, no problem. We'll put a cash offer in on your place, put cash in your pocket, and we'll get you moving. But for those that want to save your home, which is most of the people that are watching this video, we'd like to help you do that. And like I said, those services are completely free, and we make our money on those that say, I don't want my home. So on to that second question, which invariably is, what do I need to do now, and what happens next? Okay, so the big ominous document that I told you that comes from the court, you want to make sure that you respond to that. It's going to give you a time frame. It's usually about 20 days, and it'll say you must respond within 20 days. Now, you may need to get a piece of paper and a pen to write this down. Do yourself a favor and bookmark this web page so that you don't lose it, so you can refer back to it and go back to this video in case you forget some of this stuff, so you can get yourself some help later on in case you forget some of this stuff. But here's what you need to do. You must respond to this, and you must respond in writing, and you must respond right away, and you must send your response not only to the court, but also to the other attorney. And you got to do it in writing. That's critical. I don't care who you call or who you talk to. I want you to remember this rule of thumb. Nothing that you say on the phone matters. Just remember that. I don't care how many times you talk to the other attorney if you decide to talk to them. I don't care who you talk to at the courthouse. Nothing that you say on the phone matters. It goes into the bin of history as having never been said. So just understand that. If you call the other attorney and you say, this is my response to the court, I'm sending it to the court, and you don't send it to the other attorney, they say, don't worry about it. We know that you called us and it's fine. When you get to court, do you know what the other attorney's going to say? We never had that phone call. So nothing you say verbally matters. You're certainly welcome to call the other attorney or welcome to call the court or whatever else and get information. That's fine. I'm not saying don't call and find things out. I'm saying don't think for 1 minute that what you tell them holds any weight. The only thing that holds weight is what you put in writing. Now, I want to pause here for just a moment to talk to you about one specific exception to this rule that what you say doesn't matter, only what you put in writing matters. And it's this: if they're recording the phone call. If they're recording the phone call, then everything you say matters because they have proof that you said it. So since everybody pretty much records phone calls these days, why would I say that it doesn't matter? Here's why. Most of the things that you're going to say are going to benefit you. And do you really think they're going to bring that to court? Assuming they don't have somebody ordering them to bring it to court, etc. They're certainly not going to volunteer it. So in the scenario where they're recording, yes, it would matter if somebody brings it to court and they can prove that they had a legal right to actually record it. So just know that if they say these calls are recorded for quality assurance and monitoring, whatever else, it can be used, okay? So just be prepared for that. But the likelihood is very low, especially with things that would help you. They're probably not bringing that to court. So let me encourage you, find out the laws in your state because they differ from state to state. Talk to an attorney and record the call yourself because that is the scenario where you can use what you say and what they say against them in court and prove that you did have a conversation. But understand the law before you record, because I think it's a felony to record without doing it according to the way the law wants you to do it. And make sure that you alert them that you are recording, and that should take care of it in most states. But talk to an attorney and do your research before you record. But that's the one scenario where saying something that normally goes into the dustbin of history actually sticks with you and goes with you to court if it's recorded and was done legally. So you need to respond to the court with all the reasons why you don't think you should be in foreclosure. Now, this is an area where I can't give you specific advice, and I can't even give you a lot of general advice because then that's probably going to be misconstrued as legal advice. So the best thing I can tell you is go online and do a Google search for how to respond to a foreclosure action, or I'm in foreclosure, what do I need to say to my bank, or how do I respond to the court in a foreclosure action. Look up some of those keywords on Google and see what you can find. You'll see some great sample letters and you can start there. Again, best idea is always to have an attorney, but short of that, this is a really good opportunity. Now, the next step is you need to go to court. Do not underestimate the power of showing up on that court date. Here's why. If you don't show up, the other side wins by default. Now, even if you're in a ridiculously difficult situation where you're obviously in the wrong, which is the majority of foreclosure cases, just to be honest with you, the people are usually non-paying, and it means the bank has a right to sue you and take the house back. But even in that situation, if you don't show up, they win the first shot, and it's virtually undoable. It's certainly not without an attorney. So you want to make sure you show up the first time, because even if you're still going to lose eventually, this is one of those tricks that elongates the time frame, because by showing up, they don't just win that day. Remember, each time the bank wins something, from that moment forward, the process speeds up. So the bank has to win that first hearing. And if they don't win that first hearing on that day, and it's less likely if you show up, then at the end of the day, it buys you more time. What's wrong with that? Well, here's what the potential downside is. If you can't afford an attorney, you're going to have to go into court against the other side who has an attorney. But now what we're dealing with is a pecking order of lesser of two evils. There is the evil of not showing up at all, or the evil of showing up but without an attorney. The best solution that doesn't contain evil, depending on how you think about attorneys, is to hire an attorney. But if you can't afford one, or there's just no way that you can do it, the next best thing, the lesser of those two evils, is to go. Under no circumstances, for any reason, should you miss your court date. Look at that paperwork, put it on your own calendar on your phone, write it on a physical calendar if you have it in your house. Be at that court date. Do not miss it under any circumstances whatsoever. Whatever you're telling the court, you got to tell the other attorney in writing in a physical letter. You don't have to certify it to the other attorney. Just mail it to them. That's fine. If they don't get it, it's on the postal service. You can just go before a judge and honestly say, I sent it, Your Honor. I don't know what happened. All right. So after you send that off to them, the other thing is you got to send it to the court, right? There's only two ways you should do this. The best and most prudent way to send your documents to the court is not to send them at all, but to bring them yourself physically down to the courthouse. So I want to talk to you about that process and what you should do. When you walk in, you can take a number and whatever else. And many times when they see people with a foreclosure action, one of the people behind the counter will say, look, if you don't want to wait in the line, there's a bin over here. You can just take your response and put it in the bin. And that's true. And there's nothing wrong with that, except In the rare cases where your paper falls out into the trash or something happens when they go to carry the documents somewhere else and something goes wrong, because these are human beings that until it's entered in the digital system, there's no proof that you actually showed up and responded. And if you don't show up and respond, it's the same thing as having not shown up at all, and they're going to get a default on the other side because you didn't respond. It's critical that as soon as you get that paperwork, you go down to the court and file your response. Do it right away. Don't wait till like a day before your hearing. Do it, like, stop what you're doing when you're done with this video and start writing your response and doing your research on what you need to say. All right. Now, when you go in there to do that, when they tell you you can put it in the bin, if they happen to say that to you, because they don't always say that, don't put it in the bin. Take a number and wait for an actual human being. Once you get to the front of the line and they start talking to you, they're going to take your paperwork in from you and verify a few things. And then what they're going to do is they're going to stamp that thing on the top with a court stamp. That is your proof that you went and showed up and responded properly. Now, you still need to go to court on the day of court, but this is the first step. But here's the problem. They stamp it, they put it in the bin, you walk away. What proof do you have that you went there and did that? You have none. And it's not enough to put it in the bin and take a picture of it. I threw it in the bin. Here it is the day I was there, Your Honor. What you have to do is get them to date stamp it and use the court seal, which they're going to do automatically when they take something in. And they're going to then want to put it in their little bin. And at that point, it's fine, except you want to ask them for just 1 second, can you lay it out in front of you? And you lay it out and you take a picture of the whole thing. Not too far away where you can't zoom later and see what's on the front page, but not so close that you don't get everything on the front page. You want to see that it's a response. You want to see the court seal. You want to see some of the wording. And make sure you look at your picture before you leave the courthouse and zoom in. And make sure that it's not blurry and that you can see what it actually is. That's really, really critical that you do that. Now, that will be your proof to a judge if the other side later tries to claim they never responded in time, Your Honor. And that will hurt you if they're able to say that that's true and you have nothing to prove otherwise. It's not going to be good enough to say, Your Honor, I took a day off of work. I went all the way downtown from the other side of town. I waited in line for 35 minutes, and then I responded to everything, and I dropped it off. The judge is going to say, great, prove it. All proof is on you. So make sure that you get that. Now, the alternate way that you can submit that paperwork, if you truly want to do it an alternate way, which I do not recommend, but if you'd like to do it another way, that you certainly can. The alternate way is to send a certified return receipt letter to the court. It's just as effective assuming they actually receive it. But sometimes, especially with only 20 days, what if the mail goes wrong? You did your due diligence and it gets lost in the mail. This is why you don't want to do it that way. Even if you don't have a car, take a bus. Go down to the courthouse and get this done yourself. But if maybe you're disabled and can't do that, or something's wrong with your car and you can't get down there and the bus system doesn't come close enough to you, whatever the reason is, if you can't do it, the optimal way of showing up yourself, the next best thing, do not just send it in the mail. And do not just send it certified. Send it certified return receipt. Those are two separate things that have two separate costs that you need to do together. Certified means the post office is going to make sure and prove that they actually took the thing down there. And return receipt means they not only tell you that they did it, but you get a little postcard in the mail to prove it was somebody's signature at the courthouse that it got there. It's very powerful with a judge. But like I said, the problem is if the post office screws up, you have no proof. So that's the initial set of things you need to do. You need to respond in writing. You need to send it in regular mail to the other attorney. You need to take it down to the courthouse yourself. Make sure you get it date stamped while you're there. Drop it off. Take a picture of that. And then it's short of that, if you can't go down to the courthouse, make sure to send it certified return receipt to the courthouse. And that'll make a huge difference in whether or not you're able to delay your case. But the overall point that I'm making that I hope you see is this. It's absolutely critical that you start responding right away. You lose a lot of options. There's one other really important reason that you need to respond right away, like even sooner than you're required to. If it's 20 days, do it in 2 days. The more interested you look in your case to the judge, and the more you look like you're passionate about this and it's critical to you and that you want to resolve it and you're involved, the more the likelihood is that the judge is going to rule in your favor in some areas that are going to burn the other side's bacon pretty crispy. It doesn't mean you're going to win, okay? But it means it can, A, buy you extra time. Because if you don't show up, the judge just assumes, well, they don't care about their house anyway. And that's exactly what a judge is likely to tell you. If you don't show up and you show up a few weeks later when they get the default, and then you look at the judge and say, Your Honor, I need some time. Judge, well, you do? Then why didn't you show up for your first hearing? And it's not good enough to say, well, I didn't think I'd win. You need to show up and show interest. So the first thing that's going to do for you is it's potentially going to buy you extra time because the judge may rule in your favor in certain areas, which creates delays. The word delay is your best friend. Anytime you can create a delay, it buys you more time in your home. That's a critical thing that you need to remember. But you can't create delays by waiting. If you delay, and that's the one delay you don't want, if you delay, you can't get the other delays that are critical to create the bigger delay for you of putting out that foreclosure further. So the one area you don't want to delay is in responding or calling me and getting some help right away. Do that immediately, because the sooner you do it, the more options that we have. Now, for those of you that are thinking, crap, I'm already past my 20 days or whatever the time frame is for your particular scenario, that's all the more reason that you need to contact me right away, all right? So use my web form right here on the screen, or use the phone number on your screen, 404-549-5004. 404-549-5004. Use that number and I will personally pick up the phone, or one of my people will, and we'll get to you as soon as we can. We take calls 24/7 whenever we can. We don't always answer after hours, but we try to if you've got some sort of an emergency or you need some help. And listen, if you have kids or you're in a situation where you don't have any food for your kids, we'll help you apply for food stamps. And if you can't get food stamps for some reason, we'll look into other resources for you. There's Catholic charities and other Christian charities that we're connected with that we can potentially get food for you and other things. We know that in the midst of this, you need your basic necessities to be taken care of. If you need clothing, we're more than happy to take you down to Goodwill in many cases. And I realize it's not the best selection. It's not like you're going down to, buy some name brand pair of jeans, but we'll buy you some used clothes. They're really cheap and we can buy a lot of them for you for $10. So if you need some clothes, talk to us. If you need some food, talk to us. We'll do what we can for you, even if we never get a dime out of it, because again, it's not just about the money for us, it's about helping people. So we'd love to help you in that regard. All right. So that's the very first piece of the process. And again, the most important thing is that you call us right away. Now, after that, what happens? Well, there's a myriad of things that could potentially happen after that, and there's just too many of them for me to discuss in a short video like this. And I don't want to bore you with all of them, but we have a lot of options that we can discuss with you when you call. The one big thing that you have to watch for in your case, though, is what's called a motion for default, or a motion for final judgment, and then, of course, the motion for the sale of the property. Those are the three big things that you want to be looking for. Now, if you respond in time, and then each time after that, because you can go in default anytime, each time after that a hearing is set or a response is needed, make sure that you respond in the exact same way that I just told you. Because if you ever don't respond to the judge, like I said, you can go back into that status of being in default. So you want to be watching your court case for defaults. And listen, when you come on board with us, we watch all that stuff for you. We monitor what's going on with the court system. We're constantly watching your case, and anytime anything happens, we're on it. Now, you're going to know that too, because every time the other attorney takes a move, they've got to mail you something in the mail. So in the meantime, the bottom line is keep your eye out for stuff from the court, respond to it whenever they tell you something, and look for things that say motion for default, motion for final judgment, or motion for sale of property. There's a lot of other nuances for those of you that maybe have a family member who has died that owned the property, that maybe you've moved into the property, or maybe nobody's living there, or you've got a squatter living there. We handle that type of stuff all the time. We do the most difficult, complicated stuff. We handle probate, we handle foreclosure, we handle probate inside of foreclosure. I mean, we know how to do all this stuff. We've got a staff army of people that know how to do these things. So the point being, watch for those three things, and when they come up, make sure that you call us right away and tell us what's going on. So that's it, gang. That's pretty much everything that I think is important. It's certainly not a comprehensive list of everything that's going to happen or possibly happen, but it's the most critical things that I think you need to be aware of so that you don't hurt yourself in the process. But there is one more thing. I'd like you to have something to get you moving in the right direction. A little gift from me to you. It's from my own wallet to yours. It's a $20 gift card. It's a Visa card that you can use anywhere you want. And I realize it's not a huge amount. It's $20. It's not like it's going to change the world. But it's a little something that I'd like to give you from my heart and my family to yours to say thank you so much for you stopping by, for taking the time to listen to me, and on top of that, filling out that form that you see here on the screen. Just tell me who you are, and if you're in foreclosure, it's a free gift from me to you and your family. Use it whatever way you want. I don't care. Make yourself happy in whatever way works best for you. Thanks for stopping by. I really appreciate it, and I do hope to hear from you soon. Either way, thanks so much, and God bless.